Hello everybody. Welcome to the Swiss Patent Litigation Fireside Chat. It's the 31st edition already, and it's a bit a special one because I have nothing to report from the Swiss Federal Patent Court this time because simply there was no judgment published in the last month. But as I also always reported about important things that were happening at the European Patent Office, I did not want to just skip this month's edition, but rather report on a pretty important decision of the Legal Board of Appeal of the EPO this month. That decision that I wanted to briefly discuss today with you concerns all proceedings at the European Patent Office. As you most probably all know, EPO oral proceedings, at least as we were used to, are not a given anymore. So if you had asked me 5 years ago, I would have said, well, oral proceedings are oral proceedings. You go there, you do your pleadings, and then you are happy or unhappy and you leave again. That's still the case, but you appear virtually only in first instance proceedings at the EPO at least. So during the pandemic, there was a hard shift from oral proceedings in person on site at the EPO to virtual oral proceedings by video conference. In first instance proceedings at the EPO, that's, well, in almost 100% of the cases, that's the format that we are having oral proceedings today. I won't talk about oral proceedings in first instance at the EPO today. I will only talk about second instance oral proceedings, meaning before the Board of Appeal. And just to give you a bit of perspective about oral proceedings at the Board of Appeal stage, there was a change to the rules of procedure of the Boards of Appeal. That change was first approved by the Boards of Appeal Committee in December 2020 and later on in March 21 by the Administrative Council, and it came in force on the 1st of April of 2021. And there was also a consultation upfront, so the interested circles could comment on the draft proposal of this new article. But let's first have a look at the article itself. What does it say? It's Article 15a, all proceedings by video conference. It's now hard-coded in the rules of procedure of the Boards of Appeal. And in particular, paragraph 1 is pretty far-reaching, at least at the face of it, saying just the boards may decide to hold oral proceedings by video conference at their own discretion if they consider it appropriate to do so. And as I said, there were consultations upfront, and there was one amendment that was made to the draft that concerned paragraph 2. There was a second sentence in that paragraph in the draft essentially saying that a board could also compel a party to join by video conference. And that was deleted, but no other changes were made, even though, for instance, EPI requested that this article should make clear that this only is applicable in specific circumstances like a pandemic or other states of emergency, but that remained essentially unheard. It was enacted with the wording according to the draft, which is the one that you see on the slide here. And, well, guess what happened? Different boards had a different understanding of that, but hold on a second. The slides are not shifting. There. So the enlarged Board of Appeal had a saying on oral proceedings by video conference. That was G1 of 21. And you can see here in my perception, finely chiseled head note, giving everybody a face-saving opportunity to get things resolved. Its head note says, during a general emergency, meaning the pandemic, for instance, all proceedings in the Boards of Appeal in the form of a video conference are compatible with the EPC. So no mentioning of any other situations like the normal way of life as we now have it again. It was only saying during a general emergency, video conferencing is fine. Now, as I said, different boards had slightly different opinions on what that now means. The G decision on the one hand and the rules of procedure on the other hand. There was one decision, T6/18 of 21. Yeah, you can see the head note here. That essentially said, well, Article 15a is not in conflict with G1 of 21. And the head note 4, in light of the reasons of that decision, essentially said, well, don't be so 2020, let's move on. The situation has improved. We all know how to video conference nowadays. So it's almost a similar alternative to in-person oral proceedings nowadays. So more or less G1 of 21 has become moot due to the technical development. That was one line of thinking at the boards of appeal. The other line of thinking was, Article 15a simply is no legal basis for forcing parties to have their oral proceedings by video conference. That's pretty much the opposite. That all concerned only the format of oral proceedings. That image here is kind of an introduction to Murphy's Law. I think Murphy's Law is at least said to stem from experiments from the United Air Force in the late 1940s. It's quoted most frequently like, anything that can go wrong will go wrong, and it's sometimes added at the worst possible time. And that brings me to the case that I wanted to discuss with you now. The head note there is limits to oral proceedings on request. So it's no longer about the format of oral proceedings, but it's about the very fact that you get oral proceedings at all. The decision is J6 of 22. It's already from July 2023, and I think it was first mentioned on one blog in October. I realized that only in November, so it did not get much attention by now, but it deserves a lot of attention, I think, for the reasons I will present now. But first, it's important to understand the factual background of that case, and you will understand why I introduced that with Murphy's Law. So what has happened or not? February 2021, there was a notification of loss of rights. The severance annuity was not paid. Then, well, the applicant requested in due time re-establishment of rights, all good. And then in August 21, the EPO indicated that the due care requirement was not yet sufficiently proven, and it set a time limit of 2 further months for further submissions, explanations, and/or evidence. Now, the applicant requested a term extension, and that term extension was granted. So 2 further months for making an additional submission. Well, no reaction within the extended time limit. Guess what happened? In February 22, the examining division decided that the request for reestablishment was rejected. Well, the applicant was unhappy and went for an appeal, filed a notice of appeal in due time. And then he got a notification by the boards of appeal in July that the grounds of appeal have not been filed. So it was only the formal notice of appeal and the appeal fee was filed, but no grounds. So yeah, guess what happened? That was a notification that the board sent to the applicant, grounds of appeal not filed. Any observations must be filed within 2 months. Otherwise, the board will issue a written decision rejecting the appeal as inadmissible. And now the interesting bit here is the board assumes that the appellant's request for oral proceedings does not apply to the issue of inadmissibility of the appeal. And this assumption will not be made if the appellant so states within the specified period. Now, what did the appellant do? The appellant again requested re-establishment of rights, but now for the time limit for filing the grounds of appeal. And explicitly, the appellant requested oral proceedings in case the EPO would envisage to reject the request for re-establishment of rights. So that was a clear indication they wanted to have oral proceedings. And to be complete, with the request for re-establishment of rights for filing the grounds of appeal, they presented reasons why they felt they had met the all due care requirement and why re-establishment should be granted. So that is the factual background. What happened then was in August 2023 that the decision was issued, and without oral proceedings, despite the request of the party to have oral proceedings. So that is the order. Re-establishment of rights was refused and the appeal is rejected as inadmissible. So now the catchwords of the decision, there are 5 catchwords actually. I will briefly go through the catchwords before I move on to the reasons. The first catchword is, well, pretty much standard, I would say, that the request for re-establishment must state all grounds for re-establishment and means of evidence without the possibility of submitting these at the later stage. Well, okay, at the Board of Appeal stage, I would not expect any different. That a catchword as such is not much out of the ordinary. Second catchword mentions dynamic interpretation of the EPC again. And it says, dynamic interpretation of the EPC should, well, also take into account the guarantees of fair trial. Okay, that's nothing new, but let's see what that meant in the case at hand. The third catchword says there is no absolute right to all proceedings, but it is subject to procedural principles generally recognized in the contracting states of the EPO and inherent restrictions by the EPC. So a clear indication, no absolute right to all proceedings. The fourth catchword, when all proceedings do not serve any legitimate purpose, whatever that may mean, then the requirement of legal certainty in due time prevents the board from appointing them. That now is a pretty harsh catchword because it does not say or give discretion to a board to not hold oral proceedings, but this catchword says the board is actually prevented from appointing oral proceedings. And we will see what a legitimate purpose might be. Let's see later on. The fifth catchword, finally, well, again, it's not the purpose of all proceedings to give the appellant a further chance to substantiate the request for re-establishment. Well, that again is pretty standard, I would say. So it's not the first one, it's not the fifth catchword, but it's more the 3 other catchwords in between. Rendering that decision was obviously a huge amount of work. The decisions cited by the Legal Board of Appeal, that's the list here, that's 70 decisions that the board went through and cited in coming up with the reasons of the decision. That's a huge amount of work. And these are the decisions of the European Court of Human Rights that were cited in the decision and discussed in the decision. So that was an enormous amount of work. It covers 17 pages under the heading Decision in Written Procedure. And personally, I wonder why one had to make so much effort for that. It could have been oral proceedings of half an hour, and all would have been pretty finely dealt with. So that was an enormous amount of work compared to just holding oral proceedings. Then the internal distribution code was pretty surprising, at least to me. No distribution at all. I don't think that this decision is uninteresting, not at all. We will see that. Going through the reasons of the decisions cited by the Legal Board of Appeal repeatedly mention, well, when there is no legitimate purpose, there is no need for oral proceedings anymore. One example, for instance, is when a party declares, I won't show up at the oral proceedings then it's pretty evident that there is no purpose in actually holding them when nobody will show up. Or when oral proceedings don't make sense, that was with reference to G2 of 19. That was, well, when a party, well, no, when someone requests oral proceedings who is not actually a party to the proceedings, then it makes obviously no sense. Those kind of cases were referred to here. Or there was also a mentioning of cases when the appeal was clearly inadmissible. That was also mentioned as a situation when oral proceedings could be abolished with. And one case that was mentioned in the decision was T1573 of 20. And when you look at that case, actually, that one was in one sense very similar, and in another sense totally different. What was similar was, well, no statements of grounds of appeal were filed in that case. You can see that on the slide. And here the board mentioned that it is expected that the appeal will be rejected as inadmissible. Well, no surprise. And the board indicated any observations must be filed within 2 months. And what happened here was nothing. The party did not respond anymore at all. So the board here took that as an indication that there was no interest anymore of the party, because despite an invitation that observations must be filed within 2 months, the applicant did not react anymore. And there the decision was issued in writing. And we have seen that in the beginning of my presentation. In the present case, that was totally different, because there was a request for re-establishment and there was a reasoning why the due care requirement was met. Now, getting to the reasons of the decision that are troubling me, here's one on the slide. The Legal Board of Appeal says, well, in all these examples that the board discussed, oral proceedings would just unduly prolong the proceedings. And, well, legal certainty in due time is another requirement that has to be met, and oral proceedings would just serve no legitimate purpose. And apparently the Legal Board of Appeal held that's pretty much the same situation here. I doubt that this is the case, but that's what the reasons say. And oral proceedings do not serve any legitimate purpose. Again, in paragraph 37, then legal certainty in due time trumps and even prevents a board from appointing oral proceedings. Here again, it's prevention. It's not just discretion of the board, but because there is a demand for legal certainty in due time, that trumps anything else, and the board is prevented to appoint oral proceedings in situations when they don't serve a legitimate purpose, which is a pretty, well, vague term, if you ask me. Now, moving on in the reasons, again, the Board of Appeal says, with reference to the European Court of Human Rights, the decisions of that court, they also said when oral proceedings serve no purpose, when it would only prolong proceedings, then it's to no one's avail. And the Legal Board of Appeal concludes from these judgments that a narrow interpretation of the Article 116, narrow meaning, well, their parties have an absolute right to oral proceedings, That's what the Legal Board of Appeal understands as a narrow interpretation that has to make way for a dynamic and evolutive understanding. I'm always nervous when I read that in recent times, the dynamic and evolutive understanding of the law, but maybe it's just me. That is a very important paragraph in the reasons of the legal board. It's a construction of the law, the purpose of Article 116, and the legal board says, well, it's providing for the essential right to be heard, but only insofar as these serve a legitimate purpose, whatever a board may understand as a legitimate purpose, and thus do not run counter to the requirement of legal certainty in due time as a further essential feature of a fair trial for all parties. Now that is interesting. So that is again legal certainty in due time in relation to the right to all proceedings of a party. I'm not sure if I really see that on the same level, and in particular the fair trial for all parties. Well, in the case at hand, there was only one party, and it should be a fair trial for that party only. But yeah, that's at least what the Legal Board of Appeal says, what is the very purpose of Article 116.1. Then again, in paragraph 52, and that's maybe the reason why the Legal Board of Appeal took so much of an effort to come up with a reasoned decision on that particular case. It does not say in cases of re-establishment, it says in a case like the current one. So in my reading of the judgment, it's clearly reaching beyond presumably unfounded requests for re-establishment. It's really about cases that, in the judgment of the board, don't require oral proceedings because they would not serve any legitimate purpose. So here the Legal Board of Appeal says in a case like the current one, legal certainty in due time, just as procedural economy, that's yet another criterion, as a further essential cornerstone of a fair trial, has to prevail. That's giving boards of appeal pretty much leeway in cases like the current one to also consider procedural economy and certainty, legal certainty in due time, as a measure in the assessment of whether or not it's necessary to hold our proceedings. That's a pretty lengthy paragraph, but it's still a very interesting one, because here the board says, well, we are a public service provider, we have limited resources, and we have to be careful in appropriately allocating these resources, which is pretty interesting, I would say. If a court has not enough resources, it is not up to the court to come up with, well, ways to interpret the law in a way that makes it more easy to allocate the resources. But yeah, I find that a bit problematic. Then, yeah, the highlighting on the bottom that yeah, when you give a party to the proceedings, or a proceedings that don't deserve them because it would not serve any legitimate interest, other parties would have to suffer, their cases would be postponed, and this runs counter to the board's duty and function to equally bring justice to all. Well, my answer would be, if you have not enough resources, you need to get more Board of Appeal members in order to serve everybody in an appropriate way. But yeah, so that is a bit my summary and my concern about that case. Bad cases make bad law. So that case was really a bad case. So you did something wrong, you missed the deadline, you requested reestablishment for rights, you don't get it because you don't reply, then you go to an appeal, you miss to file the grounds of appeal, you again have to go for reestablishment of rights in order to get your first reestablishment for not paying the annuity. That is really a bad case, and it doesn't make a good standing at a Board of Appeal. So I understand the judge when you get that case on your desk that you are not in the mood of being very well, friendly with that applicant. I have quite some understanding for that, but still I'm worried about the bad law that might came out of this, because it's really coming with reasons that reach far beyond just cases of reestablishment of rights. And remember, it is not that the applicant did not provide any grounds why they at least felt that reestablishment should be granted. They came up with grounds. It's just that the legal Board of Appeal felt, well, those grounds are obviously insufficient, and there are holes in the argument, and they have no chance to fill the gap anyway, so we can decide in writing. But that's to me quite harsh, and maybe quite a stretch of the right to all proceedings that a party at least used to have, maybe doesn't have anymore. Now, where do we stand in that case? Interestingly, there is only one decision that recently cited that J decision of the Legal Board of Appeal, and this is decision T 2024 of 21. And that decision is quite interesting because there an applicant repeatedly requested oral proceedings, but the examining division simply refused to appoint oral proceedings. And at some point, the applicant, just requested, okay, then issue a decision in writing, and I will go for an appeal. And he withdrew the request for oral proceedings just in order to finally have the chance to go for an appeal. And here, the Board of Appeal mentioned, well, it's an extremely important procedural right to have oral proceedings. And if such a request is made, such proceedings have to be appointed. It's mandatory, and it leaves no room for discretion, meaning a party has an absolute right to oral proceedings. And all other considerations like speedy conduct, equity, or procedural economy cannot take precedence over this right. Now, doesn't that in a way conflict with catchword 3 of the J decision? And also the other bits a line below, speedy conduct, equity, procedural economy, that's exactly what the Legal Board of Appeal said, which does play a role. This board in that paragraph said, well, no, it doesn't. And these 5 decisions that the Technical Board of Appeal mentioned here are not amongst the 70 decisions that the Legal Board of Appeal cited. So that Technical Board of Appeal definitely took note of the Legal Board of Appeal decision that I just mentioned. And that also becomes clear in the next paragraph of that decision, because it mentions in passing the decision of the Legal Board of Appeal. And it has an interpretation of the Legal Board of Appeal decision that, well, I will just read it out. It offers a restrictive interpretation of the right to all proceedings only for very specific procedural circumstances, and that the Legal Board of Appeal does not consider that for the central area of the European grant procedure. That's, at least from the reasons of the decision, not my reading of the Legal Board of Appeal. And it would not really have been necessary, in my understanding, to spend 17 pages of reasons if it really only concerned the very specific procedural circumstances of a failed request for re-establishment of rights, for instance. And apparently that technical board of appeal is not so sure about its reading of the legal board of appeal decision, because it says according to the understanding of the present board, and it seems, well, that's maybe a very political interpretation of the decision of the legal board of appeal here. My reading is different. In my reading, it has definitely more far-reaching consequences. And remember, it's a decision of the legal board of appeal. It's not just a decision of one technical board of appeal, but it's a decision of the only legal board of appeal that there is at the appeal stage. So that decision definitely has weight, and we need to see how other technical boards of appeal read that decision. So it's not carved in stone that all other technical boards have a very limited understanding of the J decision, as this board obviously has. Now, where do we stand in that case? Interestingly, there is a pending petition for review in that dossier. The case number is R16/23. So it's a pending petition for review, and it's pending since, well, I think it's October or so, 23. And interestingly, when you go into the register, well, no, let me put it differently. In the list of pending petitions for review, you typically get, when you click on the R number, you directly get into the register and can look at all the documents. Now, that link is obviously not active here. The only active link in that case is to the J decision itself. I will now show you the J decision. Hold on a second. So that is the J decision. The J decision is anonymized. So there is no application number on the front page of the decision, also not on the PDF. But when you scroll down to the reasons of the decision, well, there is an application number here. So the anonymization of that case is, well, is pretty much non-existent if you know how to read decisions. And the other thing why I think the anonymization is moot in any event, when you go to the register and look for an appeal case number, you can just type in J006/22. Guess what you find? There you are in the dossier of that case. Yeah, and interestingly, when you go to all documents, what you see about the pending petition for review is nothing. So I requested access to that part of the dossier almost 2 weeks ago. I think tomorrow it will be 2 weeks. The only thing that I got by now are, I think, 3 tracking numbers. I filled out the form at the EPO website. First reply was, okay, here's your tracking number. Then after a few days, I got a new tracking number because it was transferred to the boards of appeal, who are now handling that case. Then the board of appeal got back to me saying, oh, it's at the enlarged board of appeal now. Here you get a new tracking number. And meanwhile, I got feedback from the registrar of the enlarged board of appeal last week, and he said he will look at it, but nothing has happened since then. I had hoped that I could present you some more details about the current state of the review procedure. Well, I can't, but I will keep you updated on that when I finally got hold on the documents from the review procedure. So that was pretty much it, what I brought with me today. As I said, no federal patent court stuff this time, only EPO stuff. But I think it's pretty important to keep an eye on these developments at the EPO too. If you know me a little bit, All proceedings at the EPO are a topic that is pretty close to my heart, and I was very concerned about the switch, the hard move to video conferencing only instead of in-person oral proceedings. But that only concerns the format. So when I now see that even the appointing of oral proceedings is now put in question when someone believes, well, they don't serve any legitimate purpose anymore, then I'm very concerned. And I hope that I'm not alone with that. So I will keep you updated on that on an occasional basis when something new pops up in the file. But yeah, that's it for today. I hope you enjoyed the session. Nevertheless, even though there was no Federal Patent Court judgments this week at stake, and I hope to see you again next week, again the last Wednesday of the month of May then. Thanks for joining, and bye-bye.